stripped away from great patriots who have been badly and unfairly treated for so long. Go home with love and in peace. Remember this day forever. Every time I read that tweet, it chills me to the core. The President of the United States sided with the insurrectionists. He celebrated their cause. He validated their attack. He told them, remember this day forever. Hours after they marched through these halls looking to assassinate Vice President Pence, the Speaker of the House, and any of us they could find. Given all that, it's no wonder that President Trump would rather talk about jurisdiction and a supposed January exception, rather than talk about what happened on January 6th. Make no mistake, his arguments are dead wrong. They're distractions from what really matters. The Senate can and should require President Trump to stand trial. My colleagues have already addressed many of President Trump's efforts to escape trial. I'd like to cover the remainder and then address the broader issues at stake in this trial. For starters, in an extension of his mistaken reading of the Constitution, President Trump insists that he cannot face trial in the Senate because he's merely a private citizen. He references here the Bill of Attainder clause. But as Mr. Neguse just explained, the Constitution refers to the defendant in an impeachment trial as a person and a party, and certainly he counts as one of those. Let's also apply some common sense. There's a reason that he now insists on being called the 45th President of the United States, rather than Citizen Trump. He isn't a randomly selected private citizen. He's a former officer of the United States government. He's a former President of the United States of America. He's treated differently under a law called the Former Presidents Act. For 4 years, we trusted him with more power than anyone else on earth. As a former president who promised on a Bible to use his power faithfully, he can and should answer for whether he kept that promise while bound by it in office. His insistence otherwise is just wrong. And so is his claim that there's a slippery slope to impeaching private citizens if you proceed. The trial of a former official for abuses he committed as an official, arising from an impeachment that occurred while he was an official, poses absolutely no risk whatsoever of subjecting a private citizen to impeachment for their private conduct. To emphasize the point, President Trump was impeached while he was in office for conduct in office, period. The alternative, once again, is this January exception, in which our most powerful officials can commit the most terrible abuses and then resign to leave office and suddenly claim that they're just a private citizen who can't be held accountable at all. In the same vein, President Trump and his lawyers argue that he shouldn't be impeached because it will set a bad precedent for impeaching others. But that slippery slope argument is also incorrect. For centuries, the prevailing view has been that former officials are subject to impeachment. You just heard a full discussion of that. The House has repeatedly acknowledged that fact. But in the vast majority of cases, the House has rightly recognized that an official's resignation or departure makes the extraordinary step of impeachment unnecessary and maybe even unwise. As a House manager rightly explained in the Belknap case, and I quote, "There is no likelihood that we shall ever unlimber the clumsy and bulky monster piece of ordnance to take aim at an object from which all danger has gone by," end quote. President Trump's case, though, is different. The danger has not gone by. His threat to democracy makes any prior abuse by any government official pale in comparison. Moreover, allowing his conduct to pass without the most decisive response would itself create an extraordinary danger to the nation. Inviting further abuse of power and signaling that the Congress of the United States is unable or unwilling to respond to insurrection incited by the president. Think about that. To paraphrase Justice Robert Jackson, who said that that precedent that I just described would lie about like a loaded weapon ready for the hand of any future president who decided in his final months to make a play for unlimited power. Think of the danger. Here is the rare case in which love of the Constitution and commitment to our democracy required the House to impeach. It's for the same reason the Senate can and must try this case. Next, President Trump will assert that it somehow is significant or it matters that the Chief Justice isn't presiding over this trial. Let me state this very plainly. It does not matter. It is not significant. Under Article 1, Section 3, when the President of the United States is tried, the Chief Justice shall preside. There is only one person who is President of the United States at a time. Right now, Joseph R. Biden, Jr. is the 46th President of the United States. As a result, the requirement that the Chief Justice preside isn't triggered. Instead, the normal rules of any impeachment of anyone other than the sitting president apply. And under those rules, the President pro tem, Senator Leahy, can preside. And of course, this makes perfect sense. The Chief Justice presides because when the current president is on trial, if Chief Justice doesn't preside, the Vice President could preside. And it would be a conflict for someone to preside over a trial that would become president if there was a conviction. So there isn't that concern when you have a former president on trial, or for that matter, when you have anyone on trial other than the current president. Which is why the Chief Justice presides only in that single case, and why this is exactly the presiding officer the Constitution and the Senate rules require. As a fallback, President Trump and his lawyers may argue today that he should get a free pass on inciting an armed insurrection against the United States government and endangering Congress because, as he would put it, this impeachment is somehow unconstitutional. So far as I understand it from reading the pleadings in this case, this defense involves cobbling together a bunch of meritless legal arguments, all of them attempting to focus on substance rather than jurisdiction, and insisting that these kitchen sink objections lead the Senate to not try the case. Since they may raise these points at this juncture, I feel obliged really to address them. He may argue, for example, that he didn't receive enough process in the House, even though the House proceedings are more like a grand jury action, which is followed later by trial in the Senate with a full presentation of evidence. Even though the evidence of his high crimes and misdemeanors is overwhelming and supported by a huge public record. Even though we're going to put that evidence before